Senator Morrison, may we have a prayer, please?
Let us pray. Father, we thank you for today. Thank you for another opportunity where we have come here to deliberate, and everything that we do will be ultimate towards putting our nation, the affairs of our nation, in the right path. Open our eyes, open our minds, that when we shall have perused this document, everything that will go forth in our best interest. Thank you for a new year, and we ask that in this year, 2020, your presence will be felt among us, and you will have your way. Thank you for loving us. Thank you for guidance. Thank you for direction. In Jesus' name, amen.
Thank you so much. God is good all the time. Good. Are there any apologies for absence? I don't have any. All right. So we'll move right on into the meeting. We'll move to the reading and confirmation of the minutes of the meeting held on December 11th, 2019. We'll begin with page 1. Page 2. Page 3. Senator Morgan, anything on page 3 or page 4? Page 4. Page 5. Page 6. Page 7, just one slight edit. We have enforceability of actions against data controllers that existed, or should we just exist outside of Jamaica? All right. You have something on page 6? Okay. Page 8. If there are no further corrections, ask for confirmation of the minutes. Okay, moved by Member Cuthberg, seconded by Member Samuda. Any matters arising from the minutes? Okay. I just have a question, not necessarily a matter arising. In the on page 4, the South Africa's protection of personal information. Just for clarification, when you talk about asking for the information only once in order to request the consent of the data subject, just I mean, like literally one time? Right, and I'm asking for that because in the actual bill, it comes in the bill, and I just want it to be clear.
Just to respond to the question that you asked, yes, it's actually only once. Um, Otherwise, it means that the data controller could continuously be sending the very same direct marketing, well, could continue to direct market the data subject if it is that it wasn't only once. So what would happen under the regime now is that the data subject actually has to opt in, meaning they would have to signal to the data controller that they are willing and prepared to receive marketing from the data controller, marketing information from the data controller. So you can ask only once. So if no consent is given, then it's actually the data subject that has to come back to you and say, you can send me. Yes.
Thank you. All right. You should have a copy, a draft report of the Joint Select Committee on its deliberations. Okay. What we can do is go through that report side by side with the draft bill to ensure that what's brought up in the report is reflected in the bill, right? Okay. Okay, so just by way, just starting on page 2, you will note that there's a recap of how this committee started with the deliberations, who are the entities that made their submission, or the technical teams that assisted. It gives you an overview of the bill, and then it goes into findings and recommendations. And then the specific recommendations in terms of the clause by clause begins on page 5. So that is where we would begin our comparison between the report and the bill. So, Ms. Murray?
Chair, if I might, just on page 4, under the heading Findings and Recommendations, General Observations.
Sorry, Ms. Murray. Chair, could I just suggest that we actually read the report? Read it, yeah, and we just go through it. It's not that long. It may maybe take 2 meetings. So somebody read it out. If you don't feel like reading the whole of it, you can ask others to take over. But we've done that in another committee, and it's quite useful.
So starting from page 1 then?
And I meant from page 4.
Page 4?
Yeah. I mean, the meat of the matter, unless...
All right.
Yeah.
Findings and recommendations. General observations. It was evident from the stakeholders' consultation that there was a general support for the bill, given its main purpose was to ensure the security of personal data in the possession of entities. Your committee, however, took note from the submissions that there were general concerns about the bill, particularly the powers given to the commissioner, the lack of an oversight body for the commissioner, the timeline for the implementation of the proposed legislation, registration requirements, notification of contravention or breaches, processing for the purpose of journalism, the temporary exemption for manual data held by public authorities, appointment of data protection officers, fines to be charged, the transitionary period, and the one-size-fits-all approach of the proposed legislation on all entities and the need for a tiered approach. We further noted various...
Chair, this is just an English thing. On the first sentence, there was a general support, or there was general? Just take out the a.
There was general support.
All right, okay, sorry, just go on.
No problem. There was general support.
Chair, before you proceed as well, just one observation on that.
Go ahead.
In the list of matters that would have been raised, line 5 speaks to the timeline for the implementation of the proposed legislation. That's 5 to 6, and then page 4. What the chairman would have just read. And then at line 8, it speaks again to the transition period. I think the transition period and the timeline for the implementation of the proposed legislation is the same thing, so we could delete one.
All right, thank you. So we'll delete the transitionary period? All right. We'll delete the transitionary period.
There are 2 elements to this, though, right? Because you're transitioning from some existing arrangements into a new arrangement, where there's some institutional arrangements that are going to become subsumed into this over a period of time. Is that correct? It's my recollection of what was...
But the concern from the stakeholders was mainly around the timelines for the transition, i.e. the implementation of the legislation. So the concern was around the provisions in the bill that would have spoken to a one-year transition period for purposes of implementation, and they would have recommended in those instances 2 to 3 years. So that was a concern that would have been raised by the stakeholders, which in my mind is one and the same in relation to the implementation, one and the same as the implementation of the legislation.
Yeah, because there's the institutional arrangements being put in place under this legislation to enable it to be rolled out, and appropriate timeframes being given to people who need to become aware and become compliant and do whatever is required of them. And then there are the other institutions that already exist. I can't remember what those are offhand, but there are some others that are going to be subsumed into this, administratively or otherwise. And I wasn't sure if the transition period also related to that aspect of it.
Discussion around the transition would have happened after, well, the committee's discussion around these issues would have happened after the submission. So in reporting on what the stakeholders would have raised as their concern, since this is what this first paragraph essentially is treating with,
Fine, I mean, I don't, if it's just a summary of what other people have raised concerns about, then yeah, we can continue. But so you want to remove which of them? The transition, the second one?
I believe that was what the chair and a member agreed, that transitionary period could be deleted.
So moved? Okay, we'll continue. We further noted various entities' requests for exemptions to particular provisions of the bill in light of the fact that there were other legislation and regulations governing them. However, we were informed by representatives from MSET of the instances where a data controller or his or her representative will not be required to comply with the disclosure to data subject requirements, data protection standards, and some of the provisions of the bill. The categories include national security, law enforcement, taxation, statutory functions, regulatory activity, journalism, literature and art, research, history, and statistics, information required to be made available to the public by or under an enactment, disclosure required by law or made in connection with legal proceedings, parliamentary privilege, domestic purposes, and some miscellaneous matters. Remind me what are
Chairman.
Domestic purposes, sorry.
So the domestic purposes would have purposes exclusion is that personal data which is collected for domestic use, i.e. a phone, your database for phone numbers of relatives, friends, etc., would not be covered by the legislation. So this would have been going through those things that were either exempted from the legislation or complete exemption from the legislation or prescribed exemptions based on
So it's for personal use, data collected for personal use. That's what you mean by domestic, because domestic kind of sounds on something with the home. It has a connotation which is a little different to personal use. So I'm not surprised the chair asked what that was intending to. Is that the marginal note? That's what it says? Okay.
the actual clause reads not in the amended bill that you have before you, but clause 43, personal data processed by an individual only for the purposes of that individual's personal, family, or household affairs, including recreational purposes, are exempt from the data protection standards and the provisions of Part 2 and 3.
Member Binns?
Thank you, Chairman. Chairman, I just, 1, 2, 3, 4, 5, 6, 7 or 8 lines from the bottom, where it says that MSET spoke of instances where a data controller or his or her representative will not be required to comply with the disclosure. I wondered, if that is really what we want to say, or if we want to say that there are instances of exemption. Right. It's just a little, so maybe we could just reword that.
And I'm not even sure it should begin with however, to be honest. I mean, some people want it to be exempt, and there is a list of exempt categories in the bill. Those two things may or may not coincide, yeah? Oh.
Could we say then that MSET noted the instances where a data controller, his or her representative, will not be required to comply? Yeah, that they noted the instances or highlighted the instances. Okay, thank you, Member Binns. So moved on that correction? All right, wonderful. Well, for those 2 corrections, oh, no, sorry, just one. MSET noted the instances where a data controller or his or her representative, and so on. All right, we move on to page 5, starting at the top. We raised concern about the cost of implementation of the data protection regime and took note of the response received from the Jamaica Bankers Association that the cost of compliance by financial institutions in other regions ranged from US $25,000 to US $1 million, depending on the size of the institution. Additionally, we wanted to find out the budget projection for the Office of the Commissioner and whether benchmarking was done regarding the likely cost of the entity. We were informed that a report done by a consultant engaged by MSET revealed that an estimated budget of approximately $1.7 billion was required for the establishment of that office. We were advised that the consultant recommended that the Office of the Commissioner focus in the first 3 years of its establishment on medium and large companies. The consultant also estimated an annual registration fee of 12,000 Jamaican dollars for entities.
Chair, just one edit proposed in the sentence that commences, we were informed.
Mm-hmm.
Just to say that the MSET didn't engage the consultant, but that the consultant was engaged by the International Telecommunication Union to support the MSET.
Okay.
The consultant wasn't contracted to the government?
Wasn't contracted by the government.
You mean you didn't?
Meaning the ITU, on our behalf, contracted the consultant and would have paid the consultant. But to provide us with support in reviewing and establishing the office, well, looking at what would be needed for the Office of the Information Commissioner.
Yeah, I mean, because there's a difference between who pays for it or who bears the cost of the consultant and who engages a consultant. You know, the government could have engaged a consultant with the multilateral partner, you know, funding it, or the multilateral funder could actually engage a consultant, and you wouldn't have a contract with that consultant.
So okay, so just to be clear, because we didn't want to give an impression that we actually either bore any cost or did any procurement around this issue. We did not procure the consultancy services, nor did we pay or enter into contract with the person. So that is what we wanted to be clear to ensure that there's clarity around. So while we would have requested support from the International Telecommunication Union, the support would have been provided in the form of the consultant. That entire procurement, contract signing and payment would have been done by them, of course on our behalf, but so...
so that needs to be, those words need to be inserted by whatever union on behalf of NSET.
Proposal that the consultant was engaged by the ITU to support the MSET as a...
Okay, so noted, confirmed. All right. Second paragraph, your committee is of the view that public education will be important in allowing the general public to understand the rubric of the proposed legislation.
Well, what the rubric means?
I know.
Understand the proposed
The
legislation.
proposed legislation.
Well, yeah.
All right. So moved? Okay, we'll move on to Part B, specific recommendations. Part 1, preliminary. Clause 1, short title and commencement. Members of your committee inquired whether the parts of the bill will be brought into effect on a phased basis. We were advised, it should be by MSET, right, of MSET policy. We were advised of MSET policy to bring into effect first provisions relating to the office of the commissioner before other provisions of the bill. We were told that this would ensure that staff of that office commenced working with data controllers to have them prepared for the effective date of implementation of other provisions of the bill. We support this suggestion and recommended an amendment to Clause 1.1 to indicate that different dates be provided for different parts of the bill.
Not related to what you read, but has there been a budget or something prepared by the ministry for what the office will be required to function and the staffing requirements?
Yes, which would have been the work that the ITU consultant would have done. Yes, so we do have a draft of an organizational structure, function.
Is that 1.7 billion an upfront cost of establishment, or is that an annual running cost?
Not an annual running cost, but what would be required for the initial capital injection.
What would be the ongoing cost of carrying this?
That information I don't have.
Was that included in the study?
Yeah, we did. We would have received a 3 or 4 year financial plan from the consultant, so that would have taken care of the first 3 or 4 years of the organization. I just don't have that data on me now.
Well, perhaps you can refresh your memory on it so that, you know, if there's another opportunity, we can have the benefit of that. Mm-hmm. Okay. I don't know if we're meeting again or not, but if we do, you could. Yeah. Thanks.
And Ms. Murray, based on the registration fee, it is envisioned that the fees would cover the cost of running the office based on the number of entities that would register, or government would not know? What was the estimation in terms of how many entities you'd be able to collect that figure from?
Well, I'm not sure if it was the last meeting or the meeting before of the Joint Select Committee. We would have presented to the committee our findings in relation to the size, potentially, of the data controllers that would be required to register. And this was in the when the committee would have been discussing the whole issue of who should be required to register and whether there should be some tiered registration. We would have shared at the time that using the Ministry of Industry, Commerce, Agriculture and Fisheries, MSME and entrepreneurship policy of 2017 to define what MSMEs would mean. Micro would be $15 million turnover or less. Small would be between 15 and 75, and medium would be between 75 and 425 million. That policy indicated that data obtained from the TAJ noted that approximately 97.6% of all classified taxpayers were MSMEs. And information that we got from the Companies Office of Jamaica suggested to us that there were about 100,000 companies, maybe now registered about 64,000 in total, 173,000 business name registration, those that are registered as sole traders, and 173,297 business registered in relation to business names, and then an amount of 1,973 for overseas companies. What we were told by MICAF, however, is that there is approximately between 400,000 and 600,000 MSMEs. So those would be those that are not registered as company and nor registered as under the business name. So the numbers, if we use the data from the MICAF, we would be looking somewhere in the region of about 600,000 if we're using that upper limit, not to include or may include the 100,000 from companies and or the 173,000 that are registered as businesses. And then there is a separate figure for the Department of Cooperatives and Friendly Societies, which was at approximately 100,000. So though
you can just remind me what the penalty is for non-compliance with registration. I know we went through, but I can't remember.
I think based on the recommendation of the committee, there was an adjustment that was made to that at clause. So if members are directed to the redrafted revised bill, on page 31, clause 18, which speaks to offenses, there was a revision there on the recommendation of the committee. The fine would be an amount not exceeding 2 million. And imprisonment for a term not exceeding 6 months. Or imprisonment.
So Member Robinson, remember we had reduced the penalty for non-registration. Yeah.
Is the $12,000 registration fee that has been estimated as the annual fee, is that an across-the-board fee, or is that an average of different fees for different size entities? Do you know? Is it anticipated that there will be one registration fee that everybody will have to pay?
I think that's what the consultant would have suggested, one registration fee, but the focus being in the first 2 or 3 years of the organization on the larger entities.
Boy, that's pretty harsh, though. I mean, $12,000 is more than it costs to incorporate a company in terms of fees, not statutory fees. You know, so I think to have one fee across all size entities just seems where they have a much more, it's a more nominal sum. I can't remember. I think it's $3,000 or something. You know, to form a company. Yes. when they file, they could declare their turnover or a number of employees so as to be classified if they're an MSME or if they're an M or a S or a medium or a large, and there could be different fee structures, especially if it's an annual cost that you're putting on them. So it's a $12,000 for a micro business is a whole heap. You just got rid of the minimum business tax and you're reintroducing it through this mechanism.
Mark, this is just to cover the cost of processing. We could we look at the company's office then? We could do a comparison with the company's office when you register, yeah. So we have a basis. 4,000, yeah. All right. So what I hear members saying is for us to just take a look at the company's office to see their fee structure and business, yeah, and probably model it after that so we have a basis for the fee.
Remember, they also have to pay annual return filings. If you're a company in Jamaica,
Right.
I mean, apart from your taxes, you just to exist, you have to pay you have to file an annual return, and you have to pay a fee for doing that. It's $3,000, I think. Yeah, and so you're just adding up, more nuisance costs on people.
So Chairman, and surely the cost to start a business, you have to look at it relative to, the cost of operation can be the cost to start the business. It's expected that a firm that is paying this cost would be in operation and earning. No, you don't want to create more nuisance costs and more extraction from the business being able to finance itself and invest, but it's their cost to doing business, and I don't think 12,000 is excessive or out of the range. But I would like to see the comparison also with registration.
Well, these are not startups. These are existing businesses, but they may be small. They'll be very varied in size. The numbers that you just quoted is for a range of entities of varying sizes. So I'm saying for small businesses and micro operators, persons whose turnover is less than 15 million a year, that's their gross turnover, a cost of $12,000 for them annually is a big cost. And I think it's an excessive cost.
Okay. So we're saying before we make any changes to just look at what the company's office does, whether it has a tiered fee structure or one nominal fee across the board or so on, and then we'll do that. Then we'll make a determination. All right. Okay. All right. So we'll put that one on the action item. All right, we'll move on to Part B, specific recommendations. Well, that's where we were actually. Just a few edits. In the sentence that began, we were advised of MSET's policy, but I don't know that it's a policy. It's like a recommendation, isn't it? We don't have a policy about how we bring things into effect. So I'd say we were advised of MSET's '(S) recommendation to bring into effect first provisions relating to the office of the commissioner before other provisions of the bill. And then in the next sentence, just an edit where it speaks to we were told that this would ensure that staff of that office commence working. Take off the D. Okay, so moved for clause 1. Yes. We'll move on to clause 2, interpretation and objects. This clause provides the interpretation to key terms that are used throughout the bill. Based on the concerns raised by stakeholders, your committee wishes to make the following recommendations. First one relates to accessible record. Your committee agreed to the proposal made by MSET that the word, it should be words, accessible record be deleted since the term was used in conjunction with clause 39, which was recommended should be moved to the transitional provisions of the bill.
Sorry, but does that mean it doesn't need to be defined as to what it means in the transitional provisions? Or are you going to move the definition to the transitional provisions as well?
I don't think that was the rationale for deleting it. Yeah, because I'm looking at 39 as it was then, and I don't think it was even really used there.
Can you recall why
We had recommended. Sorry. No, I think it comes from the recommendation that we delete the definition of data because that is where those words were used.
say that it appeared in the definition of data which is being deleted, so that there's no further need to have that definition of accessible record. Yeah. So that just needs to be reworded.
Okay.
That sentence.
Right. Okay. So the recommendation is to reword this so that it is clear why it was deleted and what was in its place or what was put in back. Okay.
Yeah. It's being deleted because it appears in the definition of data, which is a definition which is being deleted. So there's no further use of that defined term in the bill, so it can come out.
So we accept the rewording of accessible record and the rationale for it being deleted. Okay, so I should read now. Your committee agreed to the proposal made by MSET that the term accessible record be deleted as it appeared in the definition of data which is or was deleted, which was recommended to be deleted from the bill. But then that begs the question, why was the definition of data deleted from the bill? All right, good. All right, so the committee accepts that new wording? Your committee agreed to the proposal made by MSET that the term accessible record be deleted because it appeared in the definition of data which was recommended to be deleted from the bill. That's it? So we would delete all the rest of it? Since the term was used in conjunction, we delete all of that. All right. So moved? All right, we move on to biometric data. We support the proposal made by MSET that the definition of biometric data be amended to mean any information relating to the physical, physiological, or behavioral characteristics of an individual which allows his unique identification, such as the photograph or other facial image, signature, fingerprint, toe print, palm print, footprint, vein pattern, iris scan, retina scan, blood type, height, or eye color, or such other attribute of the individual.
DNA is missing from this list, and it seems like a conspicuous omission to me. So, unless there's a good reason for omitting it, we should just include it.
Members pointed out that DNA is to be added.
So DNA is currently referenced in the definition for genetic data. So we have, for the definition, data means DNA as defined by the DNA Evidence Act of 2016.
Biometric data doesn't include genetic data.
Well, we had recommended that it remain separate. It was raised by the committee. We said that they're treating with two separate issues. Genetic looking at DNA, and biometric more of the physical attributes and or behavioral, etc. attributes as opposed to.
Okay.
Right, so we had recommended to the committee that the committee keep the two words separate,
Okay.
or the terms.
Okay. Continuing, noting that this amended definition will cover information pertaining to a person's bodily characteristics and behavioral characteristics, we felt that the term behavioral characteristics will be open to different interpretations. We were advised that whilst the term will be difficult to define, the word including should be inserted after the term along with examples. We supported this suggestion.
Are any of these examples of behavioral characteristics? So like a twitch? A facial twitch?
In the bill, it has in square brackets, insert examples of matters relating to the habits, actions, or personality of the individual. Senator, microphone.
Right, so it's not currently in the bill.
When you intend to populate that list?
So we would have recommended it as an amendment to the current definition. And so what is being reflected in the report is what the MSET would have proposed and would have found its way in the redrafted, revised for your consideration.
But it's just biometric data, to extend to behavioral patterns.
So what the research reveals is that things like your gait, your signature, keystrokes, the way in which you type, so on, can be used to determine and analyze to determine who you are and identify you. Yes, exactly. So those are some of the things that we would put in the list, CPC. So gait, signature, keystrokes, yeah.
Well, signature is in the list, but it's not treated as a behavioral characteristic.
Signature is actually there, and we would recommend to the CPC, we'll have that conversation to remove that to an example for behavioral as opposed to where it is now, based on the research that we have done. What the research reveals is that yes, signature is included in behavioral because that's a matter of how you write. What the other one we saw as an example is actually voice. So for those phones that, yeah, for a voice command, then that would be also used to identify who you are, as well as I said before, keystrokes and of course things like how you walk.
So Senator Golden, I'll know you by your walk anytime. Yes. All right. So moved or so accepted, the biometric data. Included. Right. Okay. So there doesn't appear to be any need to change the sentence, but there will be examples inserted in the bill. Right, such as gate signature, keystroke, etc. All right. We'll move on to consent. But I have to say, though, I didn't see that in the bill. I didn't see consent in the bill. It moved to a different section. Okay. Consent. Of concern was that the definition of consent was limited in terms of the method and form and did not explain the degree of consent to be obtained from data controllers. We also observed that one stakeholder was of the view there should be a specific provision outlining the requirements for consent on behalf of minors. Having considered these concerns, your committee recommended an amendment to the definition of the term consent. So consent means any manifestation of informed, specific, unequivocal, freely given expression of will by which a data subject accepts that his personal data be processed and includes any such expression of consent given by the legal personal representatives of the data subject, any individual to whom the data subject delegates the right to give or withhold consent to the processing, or C, in the case of a minor, a parent or legal guardian of the minor. We realized that there were consequences to informed consent and noted that in the DNA Evidence Act, consent was based on the categories of persons such as a suspect, a disabled person, and children. We questioned if more requirements were considered for informed consent than the general use of the term consent. In light of this, your committee agreed that in the new definition of consent, a similar provision in relation to informed consent should be provided as explained in the explanatory notes of the UK Data Protection Act of 2018. That is, at the time in question, the data subject should be informed about how his or her data will be processed. We also agreed that consent should be freely given and should not be a condition to offering goods or services. In relation to consent on behalf of minors, we were advised that the proposed definition of consent adequately addressed the matter.
Is there anything, Chair, in the bill that indicates that you can't, consent won't be deemed to be given if it is the result of being told that you can't access this benefit, or any other condition is attached to the offering of the goods or services? In the bill. In the bill.
So the new provision dealing with consent is in clause 9 of the revised draft. And if you look at page 23, that would be clause 2B, which speaks to consent not being freely given if the data subject is required as a condition for the provision of a product or service to the data subject to consent to the collection, use, or disclosure of the data subject's personal data beyond what is reasonable for the provision of that product or service.
All right, I put the paragraphs relating to consent to the committee. So moved. All right, I'm going to ask Member Currencia Morrison to pick up at data. Page 6 at the bottom, starting from data.
Yes. Your committee recommended that the definition be structured.
We agreed. We agreed.
Okay. Yes. We agreed with the proposal that the term data should be deleted, and wherever the word data appeared in the bill, the word personal should be inserted before it. Data processor, your committee recommended that the definition be structured as one sentence by deleting the paragraphs and semicolons. Health professional. We inquired whether the University Hospital of the West Indies would be considered a public health facility. We were advised that that hospital was hybrid and supported the suggestion that the definition of health professional be amended to include a new paragraph K to state the hospital established pursuant to the University Hospital Act.
Let's pause that. Yeah. So we put data processor, health profession to the committee. So moved. Accepted. Continue.
Personal data. Your committee recommended that wherever in the definition the word data appeared, it should be deleted and the term information be inserted instead. We observed that only living individuals were covered in the definition of personal data and therefore made inquiry about same. We noted that this was also a concern that was expressed by the Ministry of Health and Wellness during MSET's consultation with that ministry. We found out that it suggested by the Ministry of Health and Wellness that the medical information of deceased persons should be protected for a particular period of time.
The word was missing or something? We found out that it was suggested. We need the words we found out.
That it was suggested.
We found out.
We found out that it, or we were advised that it was.
We were advised by the Ministry of Health, or.
Yeah.
Okay.
That one.
Go ahead, member. Go ahead, member. Go ahead, member.
The AGC informed members of your committee that there were provisions in legislation of various jurisdictions to protect the right to privacy of information of a deceased person. It was also pointed out that case law suggests that the right to privacy could continue into death. In respect of the applicability of the proposed legislation to the data of deceased persons, we recommended that a similar provision to Section 44C of Trinidad and Tobago's Data Protection Act 2011 be adopted, which was worded as follows.
Into death, you mean after death?
Okay. After death.
Continue?
Yeah.
The archives of the government of Trinidad and Tobago or the archives of a public body may disclose personal information or cause personal information in its custody or control to be disclosed for archival or historical purposes if C. the information concerns someone who has been deceased for 20 or more years. We felt that this approach would allow for a common regional position. We also felt that Clause 38 of the bill should be carved out as an exception by allowing data within the 20-year period to be used for statistical purposes or a manner of research without identifying data subjects.
Or for research?
Yes.
Or, I know, a manner of research.
Oh, okay.
For statistical purposes for research?
Yeah.
All right. So there are 1, 2, 3, 4 edits to this, what do you call it, section. Instead of we found out, we were advised by. Right to privacy should continue after death.
Chair?
Yes?
These are editorial fixes. You don't really need to put them to us like a bill.
All right.
Yeah.
Just want to know that we're capturing it correctly.
Yeah.
All right. So we'll move on. Process.
Considering that the processing of data was described in the definition of the term data, which is proposed to be deleted, your committee recommended that the words whether or not by automated means be inserted after the words information or data in the definition of process. Sensitive personal data. Regarding this definition, concerns were raised about paragraphs F, G, and the use of the term philosophical beliefs in paragraph C. In respect of the term philosophical beliefs, we noted MSET's concern that the term should not be deleted since philosophical beliefs was personal and no data controller should request a data subject to share information relating to same. We sought to find out what was meant by sex life in paragraph G.
I think philosophical beliefs were personal, if you're pluralizing it. Or are personal.
Are personal.
Yeah, however you want to, but a plural form.
Yeah. Continue.
Okay. We sought to find out what was meant by sex life in paragraph G in light of the recommendation by one stakeholder that the term be defined. We were advised by representatives from MSET that the term was not defined in the data protection legislation of other jurisdictions. Whilst one member suggested that the term sex orientation should be used instead of the term sex life, we noted that the use of this term was limited and that sex life as a sensitive personal data should be considered in the broadest sense.
As a sensitive personal matter. Because data is actually plural, so it couldn't be
All right, as a sensitive personal matter.
I think it must be the first time sex life is being used in any Jamaican legislation, so we're breaking new ground.
Chair, members, with respect to the term sex orientation, I think it should be sexual orientation. I think that would have been maybe the recommendation or not.
With regard to the proposal made that paragraph G of the definition should be deleted from the definition of sensitive personal data, as the definition would interfere with the constitutional fundamental rights and freedoms, your committee recommended that the paragraph be amended to state the alleged commission of any offense by the data subject or any proceedings for any offense alleged to have been committed by the data subject. School? The committee having agreed...
Sorry, if we could go back to page 7, sorry. The third paragraph from the end, we felt that this approach, in light of the definition, so in the last line, we think it should say to be used for research purposes without identifying data subjects because of how research purposes is defined in the bill. I want to make sure that the report is closely aligned. And then under the paragraph process, whether or not by automated means be inserted, it should be before the words information or data, because that is how it's being inserted in the bill.
So research purposes are defined in the bill?
Research purposes is defined in Clause 38(1). Research purposes include statistical or historical purposes.
Ah.
Well, it might be different now. No, I mean the numbering, I don't know. And then on the process, to just say whether or not by automated means be inserted before the words information or data.
School. The committee, having agreed to delete clause 35, which made provision for the minister to exempt from the disclosure to data subjects information related to mental and physical health, school and social work, we recommended that the definition of school be deleted since the term was only referenced in that clause. Clause.
Chair, if I might, through you. Just recommending that school be replaced or be removed from page 8 and put just before sensitive personal data, since you're doing this in alphabetical order.
Ms. Murray, go through that again, sorry.
So we have school in the order of the definitions appearing after sensitive. So if we're doing it in alphabetical, the school would come before sensitive data.
Change of order, okay.
Clause 3, application of Act. Stakeholders raised concern about the extraterritorial effect of the provisions of the bill and its application to data controllers established in Jamaica or where Jamaica law applied. We questioned how obligation could be imposed on persons who had no legal obligation to enforce Jamaican legislation within their territories. We were advised by representatives from the AGC that there would not be an adverse effect if there was an additional provision relating to extraterritoriality in Clause 3, but that the clause would have to be constructed in the context of Clause 62, which deals with the minister's power to enter into negotiation with other states to exchange information with data protection authorities of that state. In light of this explanation, members of your committee unanimously agreed that the bill should include an extraterritorial provision given the reach of the GDPR and it being anticipated that other countries might have extraterritorial provisions in their data protection legislation. We recommended that the clause be worded similarly to Article 3 of the GDPR, which relates to territorial scope, which is as follows. Article 3, this regulation applies to the processing of personal data subjects who are in the Union by a controller or processor not established by the Union, where the processing activities are related to A, the offering of goods or services, irrespective of whether a payment of the data subject is required to such data subjects in the Union, or B, the monitoring of their behavior as far as their behavior takes place within the Union. Before
you go any further, just in the paragraph before, it shouldn't be constructed, I think. Is it constructed or construed? It's in line 6 of the paragraph that's headed Clause 3. Construed in the context of Clause 62.
The clause would have to be formulated. Same as constructed. Okay. All right. Drafted.
Is that what is the new?
The clause would have to be drafted in the context. Constructed is good. Right, they're saying it doesn't exist yet, so it'd have to be
Yeah, I think
constructed.
so. Chair,
Okay.
one other point on that same paragraph, clause 62 actually deals with the minister's power to make regulations. So I think we should track the language in clause 62, which speaks to makes regulations as to cooperation by the commissioner. It's not limited to exchange of information, it could be broader.
So has that
So what should we do? What should be done?
monitoring of the
I would just suggest that when we speak after the words with the minister's power, to just track the language from clause 62, which speaks to make regulations as to cooperation by the commissioner with authorities in foreign states, or however it needs to be summarized, but just for it to be clear that one, the minister is okay. So you could have, which deals with the minister's power to make regulations as to cooperation by the commissioner in foreign states, among other things.
So you're saying instead of to enter into negotiations, that should be changed to
That should
make
be changed
regulations?
to make regulations as to cooperation by the commissioner with authorities in foreign states.
Okay.
So, Chair, has an attempt been made to construct this clause? And where is it? Huh? It should be construed, okay. That's what I thought, but, you know, I wasn't going to hold out to it.
Sorry, we changed the word
This is a
constructed
new-
to construed?
Is it on page 9? Is that where the... Yes, is that the building site? See the contractor over there. Yeah. Sorry? Okay, so that is where you have basically captured what was in Article 3. Okay. I was saying that has to be construed in light of clause 62.
SG? You want to answer?
Apparently
No?
it's construed.
Who?
Not constructed.
Miss Grant? Would that be? It's not clear to me why clause 60, why this provision in 3 as to the scope has to be construed in light of clause 60 on page 83. Maybe somebody who understands that could just explain that to me.
It was in the initial stages of the discussion about the potential application of the bill to be extraterritorial. We indicated that at the time you had clause 62 which facilitated an international arrangement. So we said that if you're going to redraft 3, you would need to be mindful of what already existed from a clause 62 perspective, so that there's no inconsistency with the regime.
Okay, so
is to say that the clause would have to take into account clause 62. Yeah. Because it's really not a question of how you construe it or how you construct it. You just have to be mindful of it.
in terms of the wording, it would say that the clause would take into account the extraterritoriality in clause 3, but that the clause
would have to take into account
clause 62.
But the clause would have to take into account clause 62.
Right, which deals with the minister's power to make regulation and so on. To make regulation as to cooperation by the commissioner with authorities in foreign states about exchange information, right? Yeah. Okay. Put these changes to the committee. So moved, accepted. Article 3, or no? How far away? Yep, go ahead.
Continuing, the regulation applies to the processing of personal data by a controller not established in the Union, but in a place where member state law applies by virtue of public international law. Clause 4, Information Commissioner. Subclauses 1, 4, and 5. Your committee examined the proposals that the Office of the Commissioner should be a commission of Parliament and subject to parliamentary oversight, and an oversight body comprising of members of the government, the opposition, civil society, private sector, and the church should be appointed to oversee that office. We recommended that there should be an oversight structure for the Office of the Commissioner similar to that of the oversight structure of the Integrity Commission, the Financial Services Commission, or a combination thereof. Subclause 3B, your committee considered the concern made about the Commissioner administering the bill as well as the Access to Information Act. We were advised that the Commissioner will have oversight for both legislation and that his or her responsibility in relation to the Access to Information Act will also be provided in that legislation. We inquired whether the Office of the Commissioner would replace the appeal tribunal in that act. Your committee was informed that I think we need to take out one of them, that the Access to Information Act would operate separately from the bill. We noted that representatives from MSET anticipate that there will be amendments to the Access to Information Act to allow for one tribunal to examine matters relating to appeals under both legislation. So we are taking out one of that's there. I'm seeing a double, right. Subclause 5E. A consequential amendment was proposed for subclause 5E based on the concerns raised in relation to clause 58. We supported the recommendation that the provision be amended to include that the Commissioner also consults with persons appearing to represent data controllers in imposing the guideline. Part 2. Rights of data subjects and other. Clause 5, interpretation for Part 2. Having considered stakeholders' comments about the absence of an option to allow for a third party to act on a data subject's behalf, either via power of attorney or as a representative appointed by the court, we recommended that clause 5A2 be widened to allow persons, whether they have a physical infirmity or not, the right to choose anyone to act on their behalf, either by way of a letter of authorization or the power of attorney. We further recommended that the categories of persons listed by hierarchy in clause 5A2 A to E should only apply to persons with mental infirmities and not to persons with physical infirmities. Your committee was of the view that persons with physical infirmities should be able to choose any one of the categories of persons to act on their behalf. Yes? Okay. Clause 6, right of access to personal data. Concerns were raised about how prescribed...
Sorry, before you go, just on that issue, when we were looking at the new definition of consent, in paragraph B, it spoke to consent given by any individual to whom the data subject delegates the right to give or withhold consent to the processing. When I saw it, it struck me that it didn't use language of authorization, it used language of delegation. And I notice here, whether we've gone into the matter of who can act for who, we speak specifically to authorization by way of a letter of authorization or a power of attorney. And I was just wondering, in the context of the consent provision, whether we ought to consider being a little bit more specific about how an individual may authorize another person to give or withhold consent. We just use the word delegate, someone to whom the data subject delegates that right. Whereas here we're more specific about who can act on behalf of another person, or what form the authorization needs to take place. It just struck me that the approach is a little different, and maybe given how fundamental the whole consent issue has become, we ought to look at that.
Doesn't it says any manifestation. Does that mean you can choose how you do it? Any manifestation, it says consent means any manifestation.
Right, but when you go down to B, it's talking about who can give it on behalf of you. And it says any individual to whom the data subject delegates that their right to give that consent. So in this instance, A must manifest consent. If A is giving consent, they have to manifest it in a way that shows that it's informed, specific, freely given, etc. But B can also do it on behalf of A, if A has delegated the right to B to do it, to give that consent on their behalf. But I'm just saying, just using the word delegation there doesn't really make it clear what form that must take. And that, whereas in this subsequent provision where we're discussing who can act on behalf of disabled persons, we were a little bit more expansive as to what form that authorization should take. And it just occurred to me that maybe we ought to look at whether the paragraph B in the new consent definition ought to be a little bit more specific as to how A can consent on behalf of B. That's the point I'm making.
Ms. Grant, any comments?
It's really policy whether we want to require that delegation to be evidenced in writing or some other form.
Well, if a consent is being given by someone else on my behalf to my personal data being used, ought not to have some kind of formal requirement to evidence that it is in fact so. I mean, it seems dangerous.
I agree.
Yeah.
So could we look at that to see if it can be a little bit more specific?
Well, I would need to know what level of formality. Is it that writing will suffice? Because in that case, you could just add the words delegates in writing.
Yes. I don't think you need a formal stamped recorded power of attorney or anything, but
All right, so we will add in writing where it says to whom the data subject delegates. In writing. Yeah. Continue, please.
Clause 6, right of access to personal data. Concerns were raised about how prescribed fees would be calculated and whether the fees would be prescribed without consultation. Confidential information being shared with persons who were not customers of a bank, the time period within which a data controller would comply with a data subject's access request in comparison to the time period within which a data subject would make a complaint, the commissioner referring a matter being investigated by him or her to a mediator, the characteristics or qualifications of the duly appointed mediator, whether the clause would be applicable to credit bureaus, and the clause being drafted to restrict the improper usage of right of access. With regard to financial information, MSET's research did not find that banking information was exempted from a subject accessed request. In respect of the fees in clause 6, 5A and B, we were told that this would be determined by the minister based on consultation and placed in regulations. We found out from representatives from MSET that the 30 days time period in subclause 4 should remain, since this period was similar in the data protection legislation of Canada, Trinidad and Tobago, St. Lucia, Antigua and Barbuda, and most European countries. In respect of the concern about the mediator in subclause 8, representatives from MSET were of the view that it was not necessary to define a duly qualified mediator, since within the jurisprudence, a qualified mediator would be certified. Furthermore, we were advised that the inclusion of a provision relating to a mediator should provide the commissioner with an option on how to resolve a dispute between a data controller and a data subject regarding the data subject's request.
Chair, I had a comment, but on the provision before clause 5. I'm asking that you replace the word infirmity or infirmities with impairment.
That's how the Disabilities Act is.
Right, so the Disabilities Act talks about a person with a disability has physical, sensory, whatever impairment. Infirmity is not quite politically correct anymore.
Mr. Morgan, Senator Morgan, Member Morgan, you want to pick up subclause 2C?
Chair, just on clause 6, in line 2, we're recommending that the word financial be inserted between confidential and information, so that it's clear that the banks were actually speaking about financial information and not information generally. And the sentence that comments, we found out from the representative from MSET that the 30 days time period in subclause 4, might I suggest that we found out from the change to it was suggested by representatives? It was suggested because it was really a suggestion that we retain the 30 days time period. So it would read, it was suggested by representatives from MSET that the 30 days time period, etc.
Yes.
Subclause 2C. In respect of clause 6.2c, we were advised that a data subject has the right to be provided with data in an intelligible form upon the payment of a prescribed fee. we were advised that the intelligible form would not be sufficient for persons who have an audio or visual disability, and therefore information should be in a form that was easily understood. We recommended that the words "or accessible" be included after the word "intelligible" in paragraph C, clause 7.
Does that mean it could be unintelligible as long as it's accessible? How you dealt with it in the actual draft?
It says intelligible and accessible.
You could look at
Page.
clause 7.2 in the revised version, where we have actually dealt with it in a separate provision rather than trying to. Yeah.
Thank you.
Clause 7. Your committee recommended that no amendment was necessary for this clause. Clause 8. Your committee recommended that no amendment was necessary for this clause.
Sorry, Senator. Just since the way the bill dealt with this issue is not the way that it was proposed in the bold sentence, rather than it appear that the committee made a recommendation as to how the word should be inserted and that wasn't followed, can we just change the wording of that sentence to just make it clear that we recommended that the provision be drafted so as to provide for accessibility in those circumstances, or something general? And it's been done through the drafter having appropriately addressed it in the bill itself.
Ms. Grant, how would you address that?
Could be that provision be made to ensure accessibility by persons with physical disabilities, physical impairments.
Clause 9. Personal data held other than in a relevant filing system by a public authority. We noted MSET's concern that cost should not be a determining factor on whether a data subject should be able to access their information that was held by a public authority. We noted that Clause 8.1 and 39 outlined similar provisions as in Clause 9.1 and 2 in providing a data controller with the right to refuse a subject access request where further information was required from the data subject. Considering this, your committee recommended that the clause be deleted. New Clause 10. One stakeholder indicated that consideration be given to requiring data controllers who operate websites to acquire the consent of data subjects before being placed on call and email lists, and to allow data subjects to be informed that their information would be passed on to marketing companies. However, we noted from the submissions of other stakeholders that data subjects should be given the option of opting out. We had concerns in relation to the obligations being placed on data subjects to opt out of receiving information for direct marketing purposes, and felt that data subjects should be given the right to opt in. We found out that the bill in its current form made provisions for data subjects to opt out of not receiving information for the purposes of direct marketing, as well as to opt in. We also found out...
Senator, sorry. Could we just request all these "we found out" formulations to just be changed to "we were advised"? Yeah.
We also found out that in order we're advised that in order to process personal data, consent would have to be given by a data subject for the purposes of direct marketing, and a data controller being required to indicate prior to the processing the purposes for which data would be collected and used. We learned that many jurisdictions allowed for an opt-in approach from the standpoint of requiring consent to use the data in the manner stipulated for direct marketing, but these states also provided for an opt-out regime. After a lengthy discussion, we agreed to delete the provisions in Clause 10 and replace same with a similar wording to that of Section 69 of South Africa's Protection of Personal Information Act 2013, which outlines the rights of data subjects regarding direct marketing by means of unsolicited electronic communications, directories, and automated decision making.
No apostrophe needed after subjects there.
Yeah.
Considering this, we agreed to delete Clause 11 of the bill, which provides for the right to prevent processing for purposes of direct marketing. As a result of these amendments, the committee agreed that subsequent clauses be renumbered.
Chair, I think maybe we should just have a quick look at those clauses, because it was a long discussion that we had on this issue, and we could just have a quick...
The new Clause 10?
Well, the formulation that from the South African, the new Clause 10, was it?
Yeah, the new Clause 10. Before we move on, though, should we, in the middle of that paragraph, the first or the second, we were advised that in order to process data, should we have personal, the word personal in front of data? Okay.
Chair, if I might, while the members are considering the new clause, new Clause 10 in the bill, but just for so that the report is
you looked at this already?
It's accurate. I want to just point out that the discussion that we were having in relation to this entire discussion on the new Clause 10 was actually in relation to Clause 11 of the bill. The committee did not recommend any amendments to the existing Clause 10. So there are no amendments that have been made to the existing Clause 10. The conversation was around Clause 11 of the existing bill. So I think that needs to be made clear.
So this should be like
what was proposed was that we would insert a new Clause 10 and then you would renumber, but the conversation by the committee was around Clause 11, which treats with direct marketing. So
there should be Clause 11. Instead of saying new Clause 10, it should say Clause...
Right, you should say Clause 10 to be renumbered as 11 going, and then
Clause...
Right, exactly. But and then you would need to make a statement about the committee accepting Clause 10 itself, the existing Clause 10 in the 2017 bill, which treats with...
what number is it now?
It would be...
It's not there.
It would be 11 now, right, to prevent processing, which was the previous 10.
Okay. So then this is in fact Clause 10 then? Where it says new Clause 10 is in fact Clause 10? No. It's the...
When you were considering the bill, it was not Clause 10.
Right. So we're going to make it Clause 10 and then renumber everything after that. Right?
What I'm suggesting is that it might be more appropriate to treat with it as you were reviewing it and then say it was proposed that it be renumbered or that it be...
I agree, because it says it at the bottom. It says it at the bottom. As a result of these amendments, the committee agreed that subsequent clauses be renumbered.
But for the purposes of the report, all the references so far have been to the bill as it was tabled. So I think for consistency, rather than referring to new clause 10, we would refer to the clause as it actually was numbered in the table bill, which was clause 11.
And maybe there should be a sentence at the beginning of this section that all references to clause numbers in this section of the report are to the bill as tabled. So it's just clear, because we're going to be appending, or there'll be another bill with different clause numbers in it to the clause numbers in the report. So it's just to make it clear which numbers we're referring to.
So the new sentence, the new topic title should read, or new sentence should say all subsequent clauses.
So you would, where you have new clause 10, you'd just be saying clause 11, right to prevent processing for purposes of direct marketing, and then all that was read with the edits would fall under that. You would still need to insert a statement on clause 10 itself, the existing clause 10, which treats with preventing processing, and there would have been no amendments proposed to that clause by the committee.
But in the section on new clause 10, which should say clause 11, right?
But within clause 11, which we were just
that's
discussing.
Thing at the end in bold, we agreed to delete the provision of clause 10. That's not correct then. Right. That would be clause 11.
Can we try this again, Ms. Murray?
So clause 10, 2017 bill, would read, so the report would read clause 10, let's use a marginal note, right to prevent processing likely to cause damage or distress, and it would say your committee recommended that no amendment was necessary for this clause. Okay, except in the marginal notes, I'm reminded, except in the marginal notes where the word likely to cause damage or distress was deleted. So let's suppose there was an amendment proposed. So, okay, so let me do this again. So clause 10, right, your committee recommended that the marginal notes be amended to read right to prevent processing. And then clause 11, all of what is under that new clause 10 would now be the...
All right, so what do we say at the top, though?
So where you have, after lengthy discussion, we agreed to delete the provisions, it would be to delete the provisions in clause 11 and replace with a similar wording, and it goes on. Because it's really clause 11, we're deleting although we're replacing it.
So instead of this saying new clause 10, we're going to change that to clause 11 as tabled in the bill? No, just clause 11. That's going to be called clause 11, right? Delete new clause 10 and write clause 11. Okay. And after a lengthy discussion, we change clause 10 to 11. Yeah. In the body where it references clause 10, that should be referencing clause 11. All right. So in clause 11 now, okay, so what do we do with the one that says clause 11? So we delete that then, right? Okay. All right. Okay. So we move on to clause 12. Rights in relation to automated decision making.
Ready? Clause 12, rights in relation to automated decision making.
Oh, I'm so sorry. Can we go back, please, to clause 5? It's page 9. It should also, that provision should also indicate that in the report on page 9 about the clause 5, it should also include the fact that the committee took a decision to use section 3.3 of the Mental Health Act when it speaks about the persons, this hierarchy of persons. The decision was to use the term nearest relative as defined in section 3.3 of the Mental Health Act. I'm also asking the committee to consider an amendment to the existing bill because it now will speak to reason of any mental infirmity. And if you could change mental infirmity to mental impairment, that's a proposal now being made.
Chair, just one further intervention. Sorry to detain the committee on this, but on clause 9, we've looked at it again, and I'm not sure that it is reflective of the reasons why we would have recommended deletion. The concern that was raised by stakeholders was that public authorities would have been, well, the legislation would be giving public authorities an opportunity to be exempted. Those public authorities that hold manual data. So it is within that context, the recommendation was that if there is going to be an exemption for any period of time for manual data systems, then it should be extended to both public and private sector alike. So clause 9, the recommendation for the deletion of clause 9 and for it to be treated within the transition provisions was with a view to ensuring or giving a period of time for both public and private sector data controllers that have manual data sets or systems or databases, manual systems, filing systems, to be able to convert those to an automated one if before the legislation would be applicable to them. But that was really the concern, that the clause 9 was seeming to treat only with public authorities, while public authorities would have been data controllers with information, with a lot of personal data or personal information for citizens and data or data subjects.
So should we take out the issue of the cost then?
Yes, so it really wasn't a cost issue so much, but to treat with the concern that public authorities holding the bulk of the information, a special treatment was being given to them within the legislation. Those public authorities, that have manual filing systems.
Right, okay. So we would ask for it to be codified in an appropriate, because it was deleted. But you're just saying the reason for the deletion.
We deleted the clause, right, yeah. And we would have treated with it in the transitional provisions, and we're saying you would have a period of time to.
All right, so this clause was essentially exempting public authorities from the provision of the Act, right? Because of how manual they are currently, but we're just saying they will have to abide by the transitional period just like everybody else and get their
Right,
systems automated.
And a data subject, additionally, a data subject could request would request access, and you couldn't give them as an excuse the fact that you have a manual filing system.
All right. All right. So you can give us some wording for this.
Recommendation, in light of the concerns, right, so it would have been in light of the concerns raised by stakeholders that public authorities, which tend to hold the bulk of personal data, would be exempted from some of the requirements of the legislation. Your committee recommended, or us, that the clause be deleted.
Okay, so for clause 9 there is no change, so just a change in the report as to the reason for the deletion of clause 9. Okay. All right, we move on to clause 12. No?
Clause 12, rights in relation to automated decision taking. It was brought to your committee's attention that it would be onerous for companies to provide information that was not within their purview, and that exemptions should be granted to some entities such as credit bureaus and deposit-taking institutions, since their operations would be based on automated processing. While we noted this concern, we did not agree that exemptions should be provided to these institutions. Although concerns were raised about the use of the terms significantly affects and decision in subclause 1, we did not feel that the terms should be defined and the ordinary meanings should apply. A stakeholder recommended that the word may should replace the word shall in subclause 5, which would require the Information Commissioner to request a data controller to reconsider a decision or make a new decision. We noted that the data protection legislation in countries such as Barbados and the Cayman Islands use similar language to that of clause 12.5, and therefore we agreed that the residual discretion of the Information Commissioner should remain. Subclause 3b. With regard to the dichotomy of the time period of a data subject making a complaint and a data controller responding to the complaint, we supported the suggestion that an amendment be made to clause 12.3b to change 21 days to 30 days. Clause 13, rectifications of inaccuracies, etc. Your committee recommended that no amendment was necessary for this clause. Part 3, requirements for data controllers.
Excuse me, Chair. Sorry to detain you, but I just wanted to go back to page 9 of the report in relation to clause 4 and subclause 5e, where it was said a consequential amendment was proposed for subclause 5e based on the concerns raised in relation to clause 58. I would also want to add, it's not just subclause 5e, but also 5f. So to just include that as well. And it wasn't said what the consequential amendment would be, but since it's mentioned at clause 58, I wouldn't have an issue with that. So E and F.
E and F.
Ready again?
Continue, please. Member Morgan, continue, please.
Clause 15, prohibition on processing without registration. It was brought to your committee's attention that the clause was onerous and over-regulating in requiring all data controllers to be registered. Exemptions should be provided for credit bureaus and data processed for journalistic purposes, and public registered should not be, yeah. What's the correction there?
Registry?
Registers, public registers? Or registry? Registers? Registers.
Should not be exempted from the provisions. In respect of the first concern, we found out that prior to the GDPR, all data controllers in European states were required to be registered based on prior directives in the EU. We found out that since the EU regime was mature, the GDPR removed the requirements for a mandatory registration process and replaced same with an impact assessment, which a data controller would need to indicate, among other things, whether it was processing data that was likely to prejudice the rights and freedoms of a data subject. However, there was a residual power in each EU state to be able to require notification where certain activities were being undertaken, for example, processing of personal data relating to criminal convictions or offenses. It was felt that given that the data protection regime will be new in Jamaica, the Office of the Commissioner should be provided with information on all data controllers, the categories of data that was being processed, the purpose of which data was being processed, and the destination of data. It was noted that one member of your committee expressed concern about the inclusion of a registration provision in light of the fact that the EU did not require same. We did not support the suggestion for credit bureaus to be exempted. Concerning the issue raised by stakeholders about the exemption of public bodies from being registered in subclause 3, your committee also expressed concern about the same and felt that if these bodies were not registered, it might be less effective to monitor them in upholding the data protection standards. Hence, we agreed that clause 15.3 be deleted. During your committee's deliberations on clause 17, we felt that the commissioner should be empowered to determine over time companies that were required to be registered. However, we were advised that clause 15 gave the minister power by order and subject to affirmative resolution to exclude certain types of processing or data processors. Considering this, members of your committee agreed that clause 15.2 be amended to require the minister to consult with the commissioner on the types of data controllers that should be excluded from registration, and same be brought to the Parliament for affirmative resolution. Clause 16, provision of...
Sorry, apologies. Clause 15, first paragraph, the third line from the bottom, the purpose for which, instead of so the purpose for which data was being processed as a recommended amendment. With respect to the paragraph that comments concerning the issue raised by stakeholders about the exemption of public bodies, on review of clause 15.3 of the 2017 bill, it actually speaks to a public register. This gives the impression that subclause 3 of clause 15 was making a blanket exemption for public bodies, and that's not in fact what was in the bill. The bill specifically says that subsection 1, which treats with registration, does not apply in relation to any processing, the sole purpose of which is the maintenance of a public register. So while it is that the committee would have recommended a deletion of the clause, I believe it would have been because the subclause was being read as applying to public bodies generally, as opposed to the specific, what is specifically there in the provision, that is a public register.
What's the rewording?
The rewording, members, would be that you'd actually want to keep public 15.3, because what you're saying, if it's a public register, it's information that is allowed to be there. Everybody knows what is there, and therefore that public register doesn't need to fall within the registration or have to register the information, because that's publicly available already. So what the committee would be recommending is not the deletion of clause 15.3. My apologies.
Actually, you said 15.
Unless it is that the committee is actually saying that, notwithstanding that it is a public register, it would be required to register with the Information Commissioner, and that
it be retained rather than deleted. I think that was what was agreed, that they be registered. I think so.
So the report would then need to be amended, if that is what was actually agreed, to say that my apologies, I just need. The chair, just the concern raised by the stakeholders about the exemption of, it would have to be public register, a public register, not public bodies, from being registered in subclause 3.
The report doesn't follow then, right? It doesn't follow.
Right. So since the committee's recommendation was that, notwithstanding that it was a public register, it would still need to register, then the report would need to be amended to say that concerning the issue raised by stakeholders about the exemption of public registers.
So then, we would delete the sentence that said we agreed to delete clause 53, clause 15.3. Okay, committee members?
The rest of it would remain.
Yeah.
Yes, that
So
you agreed to delete it, which would mean that the public register, those that maintain a public register would also have to register.
Right. Okay. So moved. So, members, that paragraph should read, concerning the issue raised by stakeholders about the exemption of public registers from being registered in subclause 3, your committee also expressed concern about the same and felt that if these registers were exempted, it might be less effective to monitor them in upholding the data protection standards. And we would delete what was there. That clause 15.3 be deleted? No, clause 15.3 says, isn't this clause 15.3? Subsection 1 does not apply in relation to any processing the sole person. Okay, all right, yes. Sorry, I get it now. We agreed that clause 15.3 be deleted. Okay. I put to the committee members. So moved. Please continue.
Clause 17. Stakeholders raised concerns about micro, small, and medium-sized enterprises, MSMEs, having to be registered and the cost of registration. Members of your committee also expressed concerns about the likely size of data controllers that will be placed on the register. We were advised by representatives from MSET that the ministry will be guided by the MSME and Entrepreneurship Policy of 2017 in determining the registration of MSMEs. Despite this, we expressed the view that all companies should be registered and the commissioner should be able to determine subsequently after the establishment of the office the entities that were not required to be registered. One member of your committee felt that entities should not be charged a registration fee for the first registration, and the commissioner should determine subsequently, after the first registration, data controllers who would be required to pay the annual fee. Clause 18, offenses. In our discussions of the concern raised by stakeholders that the terms of imprisonment and fines were onerous in the circumstances of the offenses, we agreed that the term of imprisonment in a parish court should be changed from 2 years to 6 months, and that the provision relating to the term of imprisonment in a circuit court, clause 18.3b, be deleted. We felt that the fines in the bill sufficiently reflect the severity of the offenses. Clause 19, assessment.
Chair, just a minute before we continue. Clause 17, I think it would be best to just state at the end of that paragraph what the ultimate decision was or what the ultimate recommendation is. For example, there are no changes recommended to this clause. Because things were proposed, but we're not so sure what the conclusion is.
We didn't make any amendment to the clause, so there were no changes.
Just to state it.
Your committee recommends.
Right, your committee recommended no changes. Okay. Continue.
Assessment by commissioner required for specific processing, clause 19. The concerns raised by stakeholders in respect of this clause were the need for a criteria for the minister to determine, quote, specified processing, end quote, the subjectivity of the term, quote, substantial damage or distress, end quote, and the need for a definition for same. The subjectivity of the minister to determine, quote, specified processing, end quote, since the order would be made by him or her, and the possible subjectivity of the provision in being a harm to investigative journalism. In respect of the concern about whether the provision of the clause would impact investigative journalism, the AGC advised that the right to freedom of expression and the right to privacy have often caused problems in case law, and courts have suggested that there should be a balance between both rights. The type of information that the bill covered related to personal data as opposed to the right to freedom of expression. We're informed, again, that both rights were enshrined in the Jamaican Constitution, and the wording of Clause 19 appeared to be consistent with the standards that the right to freedom, with the standard that the right to freedom of expression should not prevent one's right to privacy under the Constitution. One member of the committee inquired about the objective of the clause, since the provision did not appear to be effective in providing protection. We found out, I'm sorry, we were advised that the clause replicated provisions of the UK Data Protection Act 1998 and the Maltese Data Protection Act 2001, which were repealed. We were advised that the policy of MSET was to allow the Commissioner to assess whether the type of processing would require a higher threshold from a data controller. Since we were not provided with a response from MSET as to the reason the provision was repealed in the UK and Maltese legislation, the member who raised the concern suggested that Clause 19 be deleted or amended.
I didn't like this. We were not provided with a response from MSET. What did I put there? No. I need a little bit different wording for that.
So we need to find out.
MSET, didn't we have a response as to why the clause was repealed?
No.
Chair, while we're waiting for that, could we just go back to clause 18, where it's of the report, where it says that we agree that the term of imprisonment in a parish court should be changed from 2 years to 6 months, and that the provision relating to the term of imprisonment in a circuit court, clause 18.3b, be deleted. I think the recommendation was in relation to deleting all of paragraph B. So that line should really read that the provision relating to the penalty in a circuit court, clause 18.3b, be deleted. Right, because that would still leave the fine that's there for circuit court.
To the term.
So it should relate relating to the penalty in a circuit court. And then it could also say, we felt that the fines in clause 13.3a of the bill sufficiently reflect the severity of the offenses.
Okay.
Chair, I think, I'm extending apologies to the committee, but there was an oversight. We didn't conduct any further research on 19, so we would have come back to the committee on several other things that were deferred. This wasn't included. So at this point in time, we wouldn't have a report to give the committee in relation to clause 19. But we would commit to doing that for the next meeting so that we can at least settle what the recommendation from the committee is in relation to that.
Continue.
Clause 20, appointment of data protection officers. Members of your committee were advised by representatives from MSET that data controllers were required to appoint data protection officers, DPOs, who would be required to investigate in an independent manner whether a data controller complied with the provisions of the bill. We noted concerns about whether all entities should be required to have a DPO, which could be onerous on small businesses, and supported the proposal for the adoption of a negative and a positive list in the consideration of the appointment of DPOs by data controllers. For the positive list, we agreed that the following entities should be required to appoint a DPO: that that is, public authorities, entities that process sensitive personal data and criminal convictions, and entities that processed data relating to a large number of data subjects. The negative list, we felt, would exclude from the requirement to appoint a DPO non-profit organizations that were established for political, philosophical, religious, or trade union purposes, and public registers.
Okay, I have just an edit. Instead of the past tense for process, it should be the present tense, process, instead of processed. In both, yeah. Continue, Mr. Member Morgan.
Clause 21, duty of data controller to comply with standards. We did not recommend any changes to concerns raised about the undue burden being placed on a data controller being required to report a security breach. The Commissioner's treatment of the information to be shared with him or her, fines, and the periods of imprisonment being onerous. Substantial breaches being reported with minor breaches being reported 2 or 3 times for the year, and protection standards being applied and used to govern the bill.
Member, we've lost our quorum.
Oh.
Right.
Permanently?
Looks like it. Looks like it.
Chair, I know no, just an observation on the clause that was just read, that the 2 last sentences where it says substantial breaches being reported with minor breaches and protection standards being applied, those weren't actually concerns, but rather recommendations that the stakeholders would have made in relation to the concerns. So the concerns would have been, as you said, report a security breach, commissioner's treatment of information, and fines being onerous. So that's where the concerns would have stopped. And then the substantial breaches being reported with minor breaches being reported 2 or 3 times for the year, and protection standards being applied and used to govern the bill, those were actual recommendations by stakeholders.
Okay. Members, thank you very much. We have to end this session. Actually, our next scheduled meeting is actually on the 22nd because the parliamentary calendar, committee calendar is full. So the next possible date that we could meet is on the 22nd, unless one of the scheduled committee meetings do not happen, in which case we will jump on it and schedule a joint select committee meeting. Thank you once again. So when we meet again, we will continue the reading of the report. Then it will be amended, corrected, and then Parliament. All right? Okay. All right. So we will begin at clause 21. 21 the next time around. Clause 21 the next time. Anything else? So if there are no other corrections, I'm going to drink. No. Okay. Meeting stands adjourned.
Easy, cool and me calm. Stepping on the place like a lightning storm. They up on the ready man a ring the alarm. So them coulda never try take the king for your man. Touch the stage anytime me perform then. Best believe everything me go on then. Tell Babylon keep cool and keep calm. Before them end up run up in a lightning storm. Forward a fi run when it